May it please the court. Good morning, Your Honor. My name is Milhem, initial M, and I appear on behalf of Mr. Stone. I seek rulings excluding 4 items the police intend to rely upon: the roadside nod, the stammered yes, the 200 grams of palladium from the car, and the 300 grams of palladium with 500 grams of cannabis from the house. I'll address each of these in turn and finish with the orders. Firstly, let us begin by contextualizing the roadside exchanges. Mr. Stone is 19, indigenous, visibly anxious, and has never dealt with police before. When asked if he had used drugs within the last 12 hours, he nodded yes despite having taken none. The roadside test that followed was negative. A little later, when asked if the palladium was his, he stammered yes. Those are the moments the Crown wants to treat as admissions. Your Honor, I submit that neither statement should be received. They are unreliable and unfair in the way they were obtained, and they bear the hallmarks of gratuitous concurrence. That is not a true confession. Queensland courts have a settled discretion to exclude confessional material where reception would be unfair or contrary to public policy under Section 130 of the Evidence Act, and demonstrated in the precedents of Ireland, Swaffield, and Driscoll. Now, when we look at these 2 utterances in that light, they don't survive scrutiny. The nod sits alongside a negative drug test. It says nothing about drug use or possession of palladium. Treating that kind of compliant behavior as an admission risks serious miscarriage of justice. The stammered yes, following search and arrest, is coming from a 19-year-old indigenous youth in obvious distress. That is exactly where gratuitous concurrence lives. These incongruences, especially in light of my client's indigenous identity, should have alerted the arresting officer that other factors such as gratuitous concurrence were at play, and the fair course of action is to exclude both. Turning now to the 200 grams of palladium from the car, what justified graduating from a random test to a vehicle search was the faulty admission to recent drug use despite the test itself being negative. If Your Honor places no weight on my client's pressured nod, the basis for invoking the search power vanishes. Nervousness and gratuitous concurrence paired with a negative test does not rationally found any suspicion of drugs in the vehicle. Therefore, the 200 grams is derivative fruit of the impugned step, and the public policy discretion is activated. The balance in Bunning and Cross weighs the nature of the misstep, the ease of doing it lawfully, and the systemic need to avoid rewarding shortcuts. Here, there was an easy path, not to escalate an instance of gratuitous concurrence in the face of a negative test. The balance favors exclusion, and Your Honor possesses the discretion to exclude evidence obtained in a way that undermines trial fairness. The car item is prima facie probative if admitted, but probative value is irrelevant when the method of obtaining the evidence corrodes confidence in the process. Therefore, the principled outcome is exclusion. Finally, the house search. Officers unlawfully entered and searched Mr. Stone's home without a warrant. They didn't rely on any Section 150 PPRA exception. There was no urgency or risk of destruction, and Mr. Stone was already in custody. An obvious, effortless, lawful means was available to them, but not taken, quite simply. These are the exact grounds upon which the public policy discretion operates. The Bunning and Cross balance reminds us of the need to deter warrantless searches where a warrant could have easily been obtained. Ridgway reminds us that even cogent, real evidence may be excluded to protect the integrity of the administration of justice. Section 130 of the Evidence Act also agrees admission would be unfair given the manner of procurement. By every metric, the 300 grams of palladium and the 500 grams of cannabis from the house should be excluded. Before I state the orders, I wish to connect the dots. In regard to the statements, the problem is with how they came about. A lack of cultural competence placed Mr. Stone, a young, anxious indigenous man, in the perfect coercive setting to elicit gratuitous concurrence. With the car, the search stands or falls with that supposed admission. Put the pressured nod to one side, and there is no proper footing to rummage through the boot of a vehicle after a negative test. With the house, the unlawfulness is staggering. No warrant, no claimed exception, no urgency, suspect already in custody. Across each branch, the same principles guide the exact same result. Exclude where the reception of the evidence would be unfair, and exclude where admitting it would undermine the integrity of the system, even if it looks otherwise probative. Those are the applications of Section 130 of the Evidence Act and the discretion in Christie and Bunning and Cross. Your Honor, I ask for the following orders. First, exclude the roadside nod and the stammered yes as products of gratuitous concurrence and as unfair, unreliable confessional material. Second, exclude the 200 grams from the car as derivative of the impugned step, in any event on fairness and public policy grounds. Third, exclude the 300 grams of palladium and the 500 grams of cannabis from the house as the product of an unlawful entry in circumstances where a warrant was plainly available and no exception applied. These orders apply settled principle to plain facts and maintain the fairness and legality the court is bound to uphold. Those are my submissions. Thank you, Your Honor, and may it please the court.